Joining us now to help us better understand the legal components of the case is Joseph Lowe, a criminal defense lawyer in Los Angeles, California. So Joseph, when we look at what's happening right now, we saw the charges first brought yesterday, and they were shorter, or I would say lesser, than those being called for on many of the streets. But I wanted to ask about the process of this. What happens, for example, when an indictment comes down? What is the type of evidence and information that goes into that decision-making process?
Unfortunately, it's not anywhere what you would think it should be. Let me give you an example. The normal process is you have the prosecutor, in this case it's Cameron, and I'm sure they selected him for a variety of reasons that may not be so obvious. But anyway, he will go in front of jurors that are picked and he will select which evidence he gives them to look at, how much of it he gives them to look at, and they will then steer, shape, avoid, or just simply say they will not answer any questions the jury has. But guess who's not there? Guess who does not participate? It is absolutely improper to have anybody from the other side, either representing family, the defendant in some cases, no one. So what it really is, it's kind of like a meeting where the government, in this case prosecutor, sits down and tells the jury what he wants them to hear, what he wants them to see, and a lot of times argues what he wants them to think. And then guess what? Suddenly there's what's called an indictment, which means the jury says there appears to be some facts to support the charges, and then they issue an indictment. This generates an old-time cliche that you may have heard before, which is you can indict a ham sandwich. It's that easy, and it's that unfair, and it's that biased and one-sided.
Yeah, and of course that's called an ex parte proceeding, I believe, and that's a problem that a lot of people have, is that there is no defense there in that room to make the counter argument. And the ham sandwich thing that's a great point, because it is the exact type of idea where you bring in the information, you bring in really the grounds that that conversation is being had on to begin with, so you essentially dictate the terms of what's going on. But when we talk about this as well, the whole reason why we're having this conversation comes back to this warrant, the execution of a warrant that took place. And since then, we've had conversations about no-knock warrants, although yesterday we did hear Attorney General Daniel Cameron say that officers did knock, did present themselves when they entered that house as well. But I want to talk about the execution of a warrant as well, how specific it has to be and how they carry that out. Can you explain that for us a little bit?
Sure. Now, generally speaking, again, a warrant has to be specific as to what it is you're looking for, where it is you're going to look for it, the why goes, that part goes to the judge, and what it is you're seeking to obtain, so that you can't just say, hey, here's a pass, go into someone's house and do whatever you want. That you cannot do. But in this case, what you're asking is, was their warrant so specific that allowed them to simply show up at any time for any reason and do nothing more than bust, blow down, come through the window, the door, pull the roof off if you want to? No, warrants do not get that specific. They leave the how or the tactics to the discretion of the officers.
Yeah, and of course, a judge has to sign off on that, I believe, too. So when it comes to the execution of the warrant for Breonna Taylor, I believe that is what happened, is that she was listed on a warrant. That address was also listed, but it was one of several. They were looking at her boyfriend, or ex-boyfriend, I should say, his house as well. There were a couple. So when it talks about Breonna Taylor, I think it's important for people to look up the right warrant as well, because I have seen a lot of fake news on this circulating around as well. But when it comes to the charges that were brought yesterday, wanton endangerment is what was used. The charge being used against the police officer in that fatal shooting. Can you explain what that means?
Sure, that's fancy lawyer language to say the following. Okay, it's not murder because you didn't intend to actually kill her. That's just what the law says right now. We'll get the facts later. Or two, okay, it's not murder, say in the second degree, because you knew you were actually going to kill her, but you didn't premeditate, you didn't think it out ahead. What this is saying is that the act, in this case, the act is the officer shooting, that act, and the verbiage is, creates a substantial danger of death or serious physical injury. So what an analogy would be to help people understand this is this. If I get in my car after drinking a lot of booze, and I drive down the street and I can't do a good job, and I run over someone and kill them, that's not murder one usually, or murder two. That's usually what they call manslaughter or negligent homicide, because I should have known that by drinking and driving, that act is so dangerous that I can seriously hurt or kill somebody. And that's what they've charged him with.
And I believe, too, that what they charged him with was not necessarily the bullets that entered Breonna Taylor, but the walls behind him, right? They were saying that he was putting the neighbors in danger when he blindly shot into the room. I believe he discharged 10 rounds himself. Is that right? Is that what they were looking at, what he did for the neighbors in the other room where I believe 3 people were?
Well, that's what we've been told they were looking at, but I encourage you and all the other wonderful investigative journalists and reporters to do the following. Demand to see every single word or piece of evidence that Cameron gave that grand jury, and demand to hear what he actually had to say, and demand a few other facts, such as why aren't we hearing how many times the boyfriend supposedly shot him? Why aren't we hearing at what time he shot versus how much time elapsed before the officer starts shooting? For example, if he shoots and then they're sitting in the hallway and they're watching their watch and they count 5, 10, 30, 60 seconds, 2 minutes, and then all of a sudden they run in with guns blazing. Come on, man, that's a much different case, isn't it? But notice how you haven't been given the specifics. They give you just enough to cause you to listen and say, oh, this is unfair, or the point is we don't know.
No, you're exactly right. And for example, even yesterday during the press briefing with Daniel Cameron, I thought it was interesting that he said all of a sudden that police did knock at the door. And I thought that was a little bit strange because for the past couple of months, we've been talking about no-knock warrants. In fact, he let his home state senator propose legislation doing away with no-knock warrants on that very narrative, only to switch it up yesterday. So I think you're exactly right. Look for the information and be objective in doing this as well. I think you're exactly right for saying that. Joseph Lowe, always a pleasure having you on the program. Thank you for breaking down this very complex issue for us.